YouTube and TikTok. We are doing a double live stream. Let's run it. Nah, not that one. YouTube, TikTok.
Wait up, run it up, run it up. I'm in the kitchen cooking up something new, yeah. She's singing along to our favorite tune, wow. Enjoying the breeze from Toronto. They admire my watch at the show. You seem like you had something to share. What's up?
Let's go.
I thought so. Okay. I'm back in this game, now you're waiting on the bench. I thought so. Okay. He's back in this place like he had left something behind. Celebration for tonight. I'm feeling ready for the night. Confidence high, we making moments to remember. And leaving behind the worries, moving forward, favor. Got a plan, but no rush, just taking it slow.
You're rocking with the best. You're rocking with the best.
Run it up, running band. It's get on my team, they know who I am. They rolling
Get
the
it.
because we plan the things that they teach, don't know how to stand.
A live review. We got to run it back from last night. Live review. We about to run it back.
Like a stage, they can't glance. You look like you wanna let go of stress. What's up? I thought so. Oh, I am the blueprint. If not, why you copy me, fam? What's up? I thought so. Okay, I cannot help that they copy. Hey, I am that dad, call me Poppy. They wish they created
on
the
his
set.
birthday.
Yes, they on my D like a jockey. When it comes to the print, I'm the blue. Who? Every complaint, draft is smooth. Supreme Elite team be the one.
Get it.
Facts. I came from the trenches. I came from riding them benches. To proving my case with exhibits. My craft is exquisite. I find where they hiding them digits. The cancer that's not in remission. Hey, please pay attention. You can't recreate the five lenses. You can't duplicate what is written. You either gonna pay the tuition or pay for assistances, or pay the mistakes when you case it, dismiss them. I come with everything that's under the kitchen. Sick,
Damn, all
I
they
haven't
want.
slept in week. They scared while I'm willing to compete. These scammers are devils and I keep them under my feet. Hey, they saying they win, I never take their prescription. They never coming from the plaintiff's position. I am the blueprint, blatant admission. Check it when I talk classes and sessions. Professionals, even the tacos respect it. Show me a win, that's not a rejection. Tell me the
Article 3.
these gurus are boring and it's stretching. These students are dumb.
Article 3 standing.
Yeah, I'm done with this lesson.
Article 3.
Still I'm a step up. Run it up, running band. It's get on my team, they know who I am.
Federal claims in the state court.
We plan on the things that they teach, don't know how to stand. On my wrist like a stage, they can't glance. You look like you wanna let go of stress. I thought so. Oh, I am the blueprint. If not, why you copy me, fam? I thought so. Okay. New culture, he running this shit. Like he came with a gun in this bitch. And he double up wins back to back. Like he ain't even done with this shit. Come to court like a dog off the leash. Dismantle the evidence, break down their claims, and he start from the top of the sheet right here. Whenever he taught, they retreat. He's a lead with his team, they supreme.
Article 3. Article 3. Federal court.
You fuck with alibi, you be in the feds. Lawful lovey, still a rookie. Can't stand on the shit that they say. He beat his case, he DCSC to submission, stipulated the disposition. Westlake, he tried to give a break. Attention they didn't want to pay. Made him.
You're rocking with the best.
Run it up, running band. It's get on my team, they know who I am.
You're rocking with the best.
All right, so we got to run it back from last night. It was a hell of a live. Now, I normally don't really laugh at myself, but we got to run it back last night. We are going to run it back from last night because last night it was something to be ran back. So, right here is the run back from last night. And I'm going to give my commentary on last night because I actually watched this twice. I was like, wow, man, it's hard to duplicate things like this, but this was, I think we need to see this again. I think this is a very important live stream I held on exclusively on TikTok yesterday. So let's go. Oh, let me make sure. subject matter jurisdiction. When you get arrested, or civil case as well, I'm gonna bring civil into it. Whatever initial court that you step into, that court has jurisdiction. Because subject matter jurisdiction is going to go back to what was a crime that was committed. The location of the offense. It took place in Washtenaw County on 3409 this drive, Biscayne Boulevard. You know, the court that is situated in that district, yeah, that court has subject matter jurisdiction. That's why they take you to that court and not take you to a court 5,000 miles away. You ever understood that? Wow. If you are getting taken into a court, they're taking you right into the court, and where the location of the offense is in that area. You notice why they take you there and don't take you 50 miles away? Right there. From the break. The courts have subject matter jurisdiction because they're bringing you into the court and where the location of the offense may have taken place, the property, if it's a foreclosure or property, the location of the property, and what the hell is this? And if it's a child custody case, you're not going into Chancery Court if it's child custody. So the courts have subject matter jurisdiction right then and there. Right then and there. They automatically have it. Not have subject matter jurisdiction. So you're arguing that the judge has to prove subject matter jurisdiction to you. Anytime that you are asking the judge questions to prove things to you, that lets me know you have no understanding of court. 100% true. You don't. This is that 1867 subject matter jurisdiction can be challenged at any time, and the proceedings can't move forward unless it's established. Once again, that is a misinterpretation, and I know where you got it from, those 1901 cases. In 2026, once again, you have to file a motion challenging the court subject matter jurisdiction. The other side gets a copy of the motion. The other side responds, and then the judge will issue his ruling and order. It doesn't mean, remember, I keep forgetting, everything is a literal interpretation. It's just so literal. No context, can't see, everything's just literal. You don't challenge subject matter jurisdiction by saying, I want to challenge subject matter jurisdiction. Your Honor, we can't proceed. It doesn't work like that. It's a procedure. If there's challenges to any courts, any orders, you have to put it in a motion or pleading. You filed your challenge to subject matter jurisdiction, the other side gets to respond. You challenge your subject matter jurisdiction doesn't mean you ask the court to prove subject matter jurisdiction. Once again, whoever does that, they don't understand court. It's just as simple as that. The judge doesn't have to prove jurisdiction to you. You have to prove the court lacks subject matter jurisdiction, just like you have to prove that the court has jurisdiction to hear your claims. And since, if we tie into the sovereign citizen spaces, since there's no basis in law or fact for a lot of reliefs that the sovereign citizens request, the judge to grant their reliefs, since there's no basis of law and fact, and since it's not recognized in a court of law, then the judge doesn't have subject matter jurisdiction over your claims. This is why the judge dismisses it, because it's outside of what the law allows. And just because you take the law and throw equity in there, it still doesn't matter. We got to stop citing equity and keep plugging equity in there to cover up and mask our lack of understanding of court. Or it's on the equity side. No. Once again, if you want to claim someone's equity, if you're requesting equity, you have to be given equity as well. So you cannot claim a breach of contract if you're in default. You can't say I'm in default.
Hold on.
Cancels the other out.
Hold on.
See the problem.
Hold on. Look at this shit here, y'all. Hold on. What happened? I'm trying to figure out what happened. They said they restricted my visibility. Every goddamn time with you TikTok.
Equity and equitable relief is under the principle of fairness and principle of fairness. While you're breached for not paying, they have a contractual right and obligation to take your stuff. You see the difference? So, get my notes. All right. All right. So, pro se litigants often mix state, federal, and state jurisdictions because of fundamental misunderstandings of constitutional law.
Say I'm lying. Say if you don't go on any site, go on any, and I mean any, go on any space in TikTok, and everybody's going to be talking about constitutional law, federal law. Federal law does not unilaterally trump state law. No, federal law does not trump state law. Not in the sense where you believe it does.
These online theories, and to be honest with you, a desire to really make your claim seem more important and powerful than what it really is. It just because you cite Article 3, just because you throw all this constitutional stuff on it, it doesn't make the judge be like, oh, let me go ahead and give him what he wants. No. In the legal world, this creates a major procedural mess. Now, let's do the breakdown part by part on why pro se litigants make these specific claims and moves and what normally happens when they do. And a prime example, no disrespect to the brother, but you could go to the Equal Footing and you could look at those 6 videos, and everything that you saw in those 6 videos, it proves my case.
Yes, and I'm going to stand on it. Equal Footing. I've seen your work. I've seen what you filed. Brother, there's no way you're going to sit here and tell me that the court granted any of those 50,000 motions you filed. I don't believe your motions are being filed. I mean, granted. From what I've seen, they've all been denied and some are being stricken. Now, I truly don't think you understand court. I truly think you're mixing constitutional and federal law in a simple state case. That is what we call a rookie mistake, because only rookies do that. Only newbies. Just because you might have been doing this for a long time doesn't mean you're still not a rookie. I mean, there's been people in this space for 10 years. They still never left first base.
Judge did not grant him relief. No, the judge was not there to answer his questions. Yes, the judge said provide relevant case law, which I always say. Court rules and procedures, which I always say. So you hear the judge saying those things. And you're going to see in his videos, Article 3, delegation of authority, 100% misinterpretations of what the brother thought he understood court. And brother, sovereign citizen. everything about that proceedings, everything that came out of his mouth, you've heard it for the past 30 years. 30 years. They all said the same thing. And that's why I concluded the brother equal footing is a sovereign citizen. Listen, remember, it's not, don't get so caught up on the name. Don't get so caught up on the name. Get caught up on the words, actions, the aggressive behavior, the argumentative behavior, and the misinterpretations of what they think they know. So, right there, they all want to shut down the argument when they hear the name sovereign citizen. Oh, no, I'm not. No, I'm not. They all want to shut the arguments down. But if you look at what they file, if you look at their wordings, if you look at the mindset, the reasoning, if you look at the Article 3, if you look at the delegation of authority, if you look at all that, the gold fringe on the flag, the wet ink signature, the vapor money theory, if you look at all those things, nobody can tell me what's the difference between the people who's raised the same arguments. You can't tax me. I'm not a United States citizen. I can make it up as I go. I don't have to follow these laws. I'm not under statutes and codes, UCC's, the common law. What's the difference between the people who raises those same claims, has those same ideologies, but rejects the name sovereign citizen, but the ones who makes the same claims, same ideologies, same words, but refers to themselves as sovereign citizens? Because there's no different from a Moor, a patriot, the Republican man on the land of the Republic, indigenous to the land, private American national. All that are just sub words, little terms used to describe a sovereign citizen. Nobody can say what's the big difference. Litigants file federal claims in state court. This is one of the major things that I see. And every time I see this in pro se litigants' complaints, it's even more of an indicator that they have no clue what they're doing in court. That's a fact. They may think they do, but in reality, the procedural missteps, I know that practicing attorneys, like great attorneys, would never make those mistakes. Pro se litigants frequently pack their complaints with federal statutes, like the Consumer Financial Protection Act, the Fair Debt Collection Practices Act, FDCPA, or Title 42 USC Section 1983. And they will put all those in their state actions. All of those things are federal statutes, which means 28 USC 1331, which means your claim arises on the face of the complaint. Your claims arise under federal laws. Why are you filing that in state court? Because as you see in this video progresses, you're going to find out what happens when you plead federal claims on the face of your complaint in your state action. And then you're wondering, why is the case getting remanded? Then you wonder why it's getting remanded to federal court. But they always file them in state court or local county court. You notice that? They always file federal claims in state court. Now, 3 primary reasons based on the data for dealing with pro se litigants for 40 years and all the reports. 1, convenience and accessibility. State courts are physically closer, have lower filing fees, and have clerks who generally are more accustomed to dealing with unrepresented everyday citizens. Federal courts are intimidating, strict, and geographically distinct. And federal courts have high filing fees. This is why 99.99% of the pro se gurus online, when you look at their case filing, all of them file and form a papyrus? Tell me they don't. Every single guru always files I call it, I'm too broke or too cheap to pay. You want to know why it's a benefit on paying the filing fee? Because when you pay the filing fee, that initial screening, which 90% of y'all never pass, the initial screening, you bypass the initial screening. 28 USC section 1915A. They got to screen your complaint for its sufficiency. When you pay the filing fee and you serve them correctly, you get straight to them answering your merits. But when y'all do this in form of paupers, because you can't afford the filing fee or don't want to pay the filing fee because you have the mindset that you just don't got to pay for nothing in life, you actually are subjecting yourself to that initial screening before the case even gets started. This is why a lot of these sovereign citizen gurus, social media gurus, what happens in their cases, which they don't want to tell you, is they'll get their informa paupers granted, but they'll get their complaint dismissed for failing to state a claim, and then they'll give them a leave within 14 or 38 days to amend the complaint and refile the complaint. You see how you're already starting backwards for your case even get before the other side can even respond. Your case is already starting backwards. That's 90% of social media gurus. All of them file informa paupers. You know what that means? None of them wants to pay the filing fee, but it's not hard to believe because they don't believe they got to pay anything anyway. They don't believe they got to pay a bill back. Somebody's responsible for it. Just because you was born, that now somebody's responsible for your life. 2, the more is better mentality. Unrepresented plaintiffs often believe that citing higher level federal laws makes their state level case, like a standard foreclosure or a breach of contract, look more serious to a local judge. AKA, you're basically trying to scare them. And these are scare tactics that normally you see sovereign citizens do with fee schedules and this and all these 18 USC RICOs and crimes you're committing. You have no way to get it enforced. They're not taking you serious. Title 18 doesn't even give private citizens a right to even utter Title 18 in the litigation. It's only reserved for federal prosecutors. Oh, hold on. What the hell? What the hell just happened? You can cite Title 18 all you want. You know what you're saying to the courts when you cite Title 18? This person clearly is a sovereign citizen. I'm still waiting for someone to prove me wrong on private individuals citing Title 18 of the United States Code in a state action or in their federal complaints. I'm trying to prove me wrong where someone has won on that argument under Title 18. I've been asking for 2 years. No one has came out, but they have no problem coming in the comments saying I'm wrong. When I say, okay, prove me wrong by you winning that. But then I got to realize that's the name of the game. Argue things that you are not directly benefiting in real life every day. Stand on things, defend things that you yourself hasn't had any benefit or success in real life. Just argue it down online, but it's not serving you no purpose in real life. I get it. I keep forgetting who I'm dealing with. Only ones who cites Title 18s in their complaints. Only sovereign citizens do it. Every day practicing litigants, whether you're pro se or professional, they already understand Title 18 gives us no right of action. So we don't even think about even considering typing it on a piece of paper. You see the difference? Because remember, the Nationals and the Patriots, they all think normal people like us, we're lost, we're confused, and they're the salt of the earth. They're the ordained, they're the anointed that God put just the knowledge just on them, and they're one of the 0.1% that knows and everybody else doesn't. Actually, nope. You can get that grandiose, I'm more important than what I really am, stuff out of here. Nope. Your fake checks don't work. The IRS is asking for the money back. Your status correction is not saving your house. You declaring yourself, you're not a U.S. citizen. They don't give two rats' asses because you are to them. Putting your house in a trust that still has a lien on it ain't working. And think about it. Not that I'm just saying, think about it. When are they ever going to come back and be like, yo, I had these people file these fake checks. Now my client owes $500,000 to the IRS. Now my client owes $600,000 to the IRS because their former clients calls me and tells me what's going on and gives me the stuff that these gurus had them file. And I have one guru that's on the hit list. I'm not going to say anything right now. I'm not going to say the name, but you're on the hit list because I got all the receipts on you. You're on the hit list. Oh, yeah. Wrong. And for the ones who say, I got this case dismissed. Oh, I know someone who got this case dismissed. No, I want to see the case citations. I want to see the docket so I can look up the context of the case so I can see why the case actually got dismissed. Because 98% of what people tell you why the case was dismissed, when you look up the case, it's never the reason why they say. Do you know how many people I caught thought that they blacked out the case filing, but not knowing that they should have added another layer of black? And they talking about they got their case thrown out for the things that they'll jump on the panel and say. But when you go behind the scenes and actually read the case, it's a technical reason that has nothing to do with their merits. See how they come online and lie? All the time. I catch them doing this all the time. Like Tempest Law Review, she does that all the time. Quite a few of them do it all the time. They'll get the case dismissed because the attorney filed their own motion to dismiss without prejudice. Oh, that's a big difference. Or they didn't serve them correctly or didn't serve them in time or didn't show up to the meeting for one of prosecution or whatever. And they'll come online and say, we got a case dismissed based on the things that I talk about or what I teach. No. You can never have a case dismissed based on the merits of your claim if you are the defendant, because only the plaintiff brings the claims. The defendants don't bring the claims. And in order for a defendant to bring a claim, you have to counterclaim, meaning the same rises of your claims are the same, the elements and the causes of the plaintiff's claims give rise to the defendant's claims. This is why you'll become the counter plaintiff and they will become the counter defendant, in which the judge will still have jurisdiction over the counter plaintiff's claims. So you need not have to establish the court subject matter jurisdiction in that case, because it's all predicated under the original complaint, because they give rise, the elements and the causes give rise to the same. But once again, they don't really understand the concept of these things. No one, when they say, oh, I got relief in the same things that thousands of others got rejected for saying the same thing, I don't believe you. And there's nothing that you can tell me. Three, misunderstanding concurrent jurisdictions. Some federal laws can be heard in state courts known as concurrent jurisdiction, like I just said. Pro se litigants often assume all federal laws can be handled by a state judge, failing to realize that state judges prefer to stick strictly to state laws. This is why it's not uncommon to have a pro se litigant in state court. In state court, have all bunch of federal questions. Is this an Article 3? No, this is a state court. Article 3 courts are courts of limited jurisdictions. Now, this is the consequence when you go and you have federal claims on the face of your complaint. You're pleading federal claims that are governed under federal law. Because if I was the other side, I would do the same thing. If I was on the other side, I would do the same thing. So I can see. Ooh, so I can see. Oh, I can. I think I've cracked the code. Okay. So the consequences, and I see it every day. If you are a pro se litigant and you are in a state court and you file a complaint in state court, especially people in these spaces, they all make the fatal error. They cite federal laws, federal claims in the state court, which leads to a removal to federal court. How many of you filed your lawsuit in the state? And as soon as you file, as soon as they respond, they remove the case to federal court. Wanna know why? Wanna know why? Because on the face of your complaint, you're not pleading state laws. You're pleading federal law. So you went to the wrong venue. And that's what the lawyers know. You're in the wrong venue. Now, the state law is not going to govern those claims now. Now, they're going to drag you out in the deep ocean and remove the case to federal court. Now, under federal law, federal rules, procedures, you haven't stated a claim. And they hit you out like that every time. Y'all get hit with the flim-flam every time. Like I said yesterday, they do y'all like that every time. You go into state court, you're mixed matching federal law and state law. That is a rookie mistake. That is a pro se social media rookie mistake. That is a person that doesn't understand court rules, doesn't understand court proceedings, don't understand how to actually format and style a complaint, don't have no professionalisms to their claims not taken seriously. So you think that you could just throw darts at the wall and hope it sticks, and it doesn't work like that in court. I get so tired of seeing people bring state filings, but everything is TILA, everything is RESPA, everything is federal. You know, and that's all they do. Oh, he's not pleading state claims on the face of the complaint, and he has not satisfied the elements under federal law. Let's just fucking take his ass out, file a notice of removal, have the case moved over to federal court, and then file a Rule 12b-6 motion. Like I said yesterday, y'all be letting them off the hook. Y'all be letting them off the hook. They move notice of removal. The bank, the lender is going to file a motion, remand notice of removal to federal court, and then bam, motion to dismiss. Tell me I'm lying. It happens like clockwork. Every day. I know. I know. When a pro se plaintiff files a federal question in a state court, they inadvertently give the defendant, usually a bank or corporation, a massive tactical advantage. Just be handing the Rule 12b-6 motion right to him. The object is for when you file your complaint, the first thing that they do when they scan the complaint, it says, damn, we're not going to survive a Rule 12b-6 motion. Nah, we're not going to survive it. So, damn, we're going to have to respond. If they are filing a Rule 12b-6 motion after your complaint, you have done something wrong. That's what they do. Under federal law, the defendant has the absolute right to remove the case to federal court. because it don't matter. It doesn't matter. I got to amend my complaint, so it's the problem. I mean, so this person made a comment as to say, I got to amend my complaint, meaning my case wasn't automatically thrown out because I got to amend my complaint. But the point that I think this person missed was your complaint, your original complaint was dismissed, and they gave you another chance to get it right because you're pro se. If you was a legal attorney, it would have got dismissed with prejudice. So just because your complaint had to be allowed to refile it, that's my point. You have to refile a complaint. When you first file it, it's never sufficient. It don't stick. See, us over here, we don't go through the judge let us refile. No, because we're gonna get it right the first time. That's my whole point. So when she make that statement, that's my whole point. You have to, the judge has to give you help, give you leeway to refile again, because it's never done sufficiently the first time. That's my point. It's my whole point. You was allowed that, but like, just I'm saying, like, yeah, it's learning pains when you are filing cases in federal court, but you really don't understand the court rules. You really don't understand the procedure. And I'm not talking about understand because I've been studying for months. I'm talking about real life experiences of being in court, experience, real life, years of being in and out of the courtroom. You ever notice how, like a sheriff's deputy, like when you're being transported, people that have been transported to court, or the U.S. Marshals, you want to know how when some police officers, you know how when you talk to them, they kind of got like a good understanding of how court works, like the evidence needed and the little in-betweens that they normally wouldn't know because they're in court all day, every day. Just like a public defender, say what you want about them, they're in court all day, every day. They're in trial all day, every day. They're in court more than the private attorneys who got their own firms. They're every day. And one thing about court is there's only so much reading you can do, so much studying you can do. You have to get the in-court experience because that is what makes you better, the experience. And a lot of you, based on your filings, even the fact that you even have to amend your complaint, that it just lets me know you don't really understand court, because court is not the time for you to be trying to figure it out as you go. We got to stop treating court like it's like an administrative process. All right, this didn't work. Okay, I'm going to try this one now. Oh, this didn't work. It's like you just keep sticking things, hoping something sticks. Real life attorneys who do this in real life, and even ones who don't have a law school or degree from a law school, but actually been in court 15, 20 years, understands the nuances of court. And that's one of the biggest things that a lot of you are going to have to find out the hard way. There's no other way around finding out and understanding the term.
There's an old Japanese legend that says,
the hell?
Get on the wrong train, get off at the first station. The longer the trip.
The fuck is going on? Have all a bunch of federal questions. Is this an article? Who governs driver's license? The states. Federal laws, you think it's Trump state's law? That's crazy. On your filings, even the fact that you even have to amend your complaint, that it just lets me know you don't really understand court. And that's the point right there. When I speak on the nuances of court, the nuances of court is the understanding that you may go into court with a game plan. You may go into court with a strategy, but you may have to abandon that strategy off within the first 5 minutes, or you wanted to raise these claims right here, but the case took a turn this way. So now you got to flow with the case and argue these claims here. You didn't get to the next 4. You got to stick to this one right here, or those in-between motions, or when you're questioned and you're challenged how to be able to break down and improve your point and shift the ball right back and the burning back to the other side. And when they hit it back your way, you hit it back. You don't understand that by being on social media. You don't understand that by reading books. You don't understand that by taking courses. You understand that by being in court and experiencing it. Experience. Prime example, the video with my client when she was in court, we had a whole game plan. We got to the first paragraph of the whole game plan and we freestyled it the rest of the way. The question she was asking, I'm in her ear. Ask it. Man, I got to play it by ear now. Okay, all right. The courts and everybody's focused on this right here. All right, we gonna throw that script over there. We going right here. Oh, they went this way. All right, now we got to flow this way. If you were just so heavily relied on the script, you're not going to be able to pivot on a dime. You're not going to be able to go this way, go this way, go this way, go that way. Oh, now we got to go this. You're not going to understand that online. That's experience of being in court. So when I say the nuances of court, that's what I mean. Court is not the time for you to be trying to figure it out as you go. We got to stop treating court like it's like an administrative process. All right, this didn't work. Okay, I'm going to try this one now. Oh, this didn't work. It's like you just keep sticking things, hoping something sticks. Real life attorneys who do this in real life, and even ones who don't have a law school degree from a law school, but actually been in court 15, 20 years, understands the nuances of court. And that's one of the biggest things that a lot of people are going to have to find out the hard way. There's no other way around finding out and understanding the nuances of court. You got to get in the field to understand what I'm talking about. And many people, the nuances of court, the ones that don't understand nuances of court, this is the conspiracy people. Oh, the judge ain't allowed this. The judge is letting the other side do what they want. The judge ain't letting that's I don't understand the nuances of court. I don't understand the intricacies, the little details of courts, the procedural posture, how it goes, type of judge you're in front of. Because many people think that their version of events is true. That's it. That's all they need, their version of events. And then another thing that pro se litigants do, and I guarantee you, 1 out of every 2 complaints that someone sends me to review, I swear to God, it never fails. They all make legal conclusions. Some of you got legal conclusions in your complaint right now. You just don't even understand the concept of why that's fatal to your claims. Some of you got legal conclusions in your complaint right now. You don't even realize you do. I'm gonna tell you what your legal conclusion is. When you recite the events what happened, and then you finish with, by doing that, they violated federal law, or they violated TILA by doing what they're doing. You see that? They violated this. They violated that. That's a legal conclusion. And courts throughout the United States of America hate legal conclusions. They hate legal conclusions. Now, once removed, that's another thing. I don't think people understand the term legal conclusion. Y'all need to go and study Ashcraft versus Iqbal. No, Ashcraft versus Iqbal and Bella Lanza versus Twombly. There has never been a pro se case that someone sent me that I read. There's never been one. There's never been one that did not have a legal conclusion. Like y'all don't even understand when you're doing it. And this is why you don't get far in your cases. Because every time you make a claim or assertion, for one, it's never backed up with factual evidence, number one, because you can't create factual evidence out of these social media online arguments. You can't create factual evidence out of a wet ink signature. You can't create factual evidence out of securitization kills the debt. or securitization, the lender got paid so they can't show injury, or double bookkeeping entries, show the books and the entries in the books, those vague terms of accounting to supplement the fact that you don't understand advanced accounting. You don't understand accounting from a balance sheet standpoint. You don't understand accounting from a Deloitte standpoint. You don't understand accounting from a PwC standpoint, to the accounting firms, Ernst & Young, who they hire to do these corporate balance sheets where they have to account for and classify billions and billions and billions of dollars of income and revenue and expenses and allocations and classifications every fucking quarter. That's the accounting that I'm talking about. I'm not talking about the buzzword accounting that you see online. Oh, absolutely not. That's why y'all lose on your accounting claims too. Getting spanked on your own accounting claims. Forced into a highly strict federal arena where they are vastly outgunned by corporate defense lawyers and face swift dismissal under Federal Rules Civil Procedure Rule 12b-6 for failure to state a claim. And that's the trick. You cite, actually, they love when you go into state court and putting all that federal claims on it. Putting all these federal claims in your state case. You want to know why? Because you think you're proving a federal claim in the state case, but when you throw the federal claims on the federal lens, it's a whole different standard. Oh, you ain't stated a claim under the federal rules. This is why they filed the motions to dismiss. Because you ain't stated a claim under federal law. And this is why they were notice of removal, remove your state case to federal court, because on the face of your complaint, you got federal claims. And this is the problem. You should never go into a state court citing federal claims. But the new culture, why would you tell them that? Because they think Article 3 standing applies in a state court, not knowing that under Article 3 of the U.S. Constitution, federal courts are courts of limited jurisdiction. They're not limited jurisdiction. They govern under state. Okay. All right. Yeah, sure. I know. We know that's what you want to believe. We know that's what you pay to learn. We know that 95% of what you learned and what you paid for has been in vain. We know that. We know that you spend way more money on packets and processes and templates, and very little understanding is gaining with it. So what you do is you call yourself knowledgeable because you can regurgitate what you heard, because you could come on the panel and repeat some things back to another person, or because you can explain how that process works, but you really don't really understand what's going on. And it's reflected in the amount of the few, far, and in between victories. And I'm talking about significant victories. I'm talking about victories that matter. I'm talking about victories from a plaintiff standpoint, victories from a property from there back over here standpoint. This is why they can't show it. This is why they can't show it. If what I'm saying is not so true, why am I the only one with the win that I received this year? Why am I the only one with it throughout this whole space? Why am I the only one? Why can't anyone else come up as the plaintiff and current and show it? Follow my blueprint, you get the same results. But for these other gurus who call themselves teachers, why haven't they done it? You notice how they can always show things that they've done for others? Ask them, what have you done on your own? You can help people discharge their autos. Well, what about your own? What about your own? I mean, I'm pretty sure a teacher who's advocating and teaching and advocating for these things, they'll be a living example in their own lives. I mean, if it's beneficial for the students, I'm pretty sure it's beneficial for the teacher as well. So I'm trying to figure out, why aren't they teachers utilizing the things that they teach? I know it ain't about them just selling people's belief systems back to them, catching people in vulnerable, desperate, ego, greedy situations and selling it back to them. I know you're just not dealing with people who really be going against their better judgment. I know you're not just looking for those people. And I know you're not looking for the desperate and the vulnerable, the ones who are in financial, difficult situations. And they're subject to go against their better judgment because their situation is so in dire need of a quick fix that they have to throw logic and reasoning out the window and pursue in the hopes of it working. No evidence that it's worked the last 2 times you went with them. No evidence that that webinar produced understanding that could lead to your own results. No, you pay for future hope. You have nothing in the past to look for, so you just hope for the future. Well, I hope it works this time. I hope I get some out this webinar. I hope I'll be able to file this from this one. It's all hope, prayers, dreams. Nothing substance. Nothing to say, I'm going to lead the way. I am going to lead the way. Follow my lead. Follow my lead. Follow me. Follow my lead. Because I did it. Here's the blueprint. Here's the blueprint. Follow my lead. The same core elements for this, I'm going to transfer it to you. There you go. Nah. You ain't going to find, they don't do that. Nah. It doesn't, you think that Article 3 really means that you could just go in anywhere, any state, and just go Article 3, and federal law is supposed to just trump state law all day? You really think federal law, no matter what the federal law is, you think it's Trump state's law? You should know that. The feds don't govern driver's license. Who governs driver's license? The states, right? The DMV in each state, right? Don't the states pass the laws for the citizens and driver's license? The feds ain't. They don't have no really driver's law. Like for citizens, they don't. Federal courts are courts of limited jurisdiction under the same Article 3 that y'all like to cite. Yeah. Did y'all skip over that part? That federal courts are courts of limited jurisdiction? See, that goes to now we get into the belief. Because if the federal judges are saying we are courts of limited jurisdiction, why do pro se litigants want to widen that net for their jurisdiction when they themselves saying we're limited jurisdiction? Why do y'all want to keep throwing Article 3 and everything? And this is, ladies and gentlemen, all you got to do is just use logic. If it sounds too good to be true, yeah. If you can still, no matter how many times they explain it, if it's still not clicking, trust your judgment. That's your higher self is telling you something. If you down inside, nah, this ain't making sense, it's because it's not. As humans, we're more connected than we are different. If it sounds too good to be true, if they're promising you that they can do this, and they can't show you that they're a living example, if they're not living by the same things that they want you to live by, and we're not talking about living by coming online with a fez or coming online talking. In real life, everyday real life, if they're not living by it, nah. I mean, they don't understand. People who really don't understand the nuances of courts. Now, part 2. Why did they drag Article 3 into state actions? The obsession with Article 3 of the U.S. Constitution in state court actions is almost entirely driven by internet legal gurus, sovereign citizen groups, and online credit repair document templates. The weaponization of standing. Article 3 limits the power of federal courts to actual cases and controversies. Right there. That is the limitations of Article 3. That's what it's limited to. Cases or controversies. The problem is 99% of these social media arguments are not they're not providing any actual live case of controversy, because the relief that they want out of these frivolous claims, the courts don't recognize. So since the courts don't recognize these as relief, then the court can't have subject matter jurisdiction over your claim. And since the court can't have subject matter jurisdiction over your claim, you have no case or controversy to present in front of the courts. You see how easy, you see the concept is so easy to understand when you're just doing things the correct way? Courts have interpreted this to mean a plaintiff must have Article 3 standing. An injury in fact, the causation, and the redressability. While state courts, depending on the action, requires a totally different set of elements. So your Article 3 in state court, you're asking for a Rule 12b6 motion. Let me be one of their attorneys and y'all come with your federal claims in the state case. I'm going to do the same thing they all do. I'm going to file a notice of removal and have your shit dismissed under Rule 12b6. Failure to state a claim. Y'all fall right off the fiscal cliff every time. Now you got to fight from up under it. Now you got to tell, no, it should stay here. Oh, it should go back. Now you got to appeal. Now, see how your own ignorance automatically puts you behind the 8 ball at the onset of your case? You want to notice that there's never a flow from your case to trial. It's always I got to fight a summary judgment. I got to fight a Rule 12b6. I got to fight this motion to dismiss. I got to fight. Y'all giving them the ammo, but you don't even know it. Don't even realize you're doing it. You think it's a conspiracy every time you get hit with a 12b6. No, you got hit with a 12b6 because you failed to state a claim upon which relief can be granted. That's why you got hit with it. There's no other, that's why you got hit with it. They don't file Rule 12b6 motions just to do it. Anytime they file a Rule 12b6 is because the way you worded it, you did something to trigger it. They're never supposed to be filing the Rule 12b6. Never. So you need to analyze yourself. Why are they filing the Rule 12b6? The weaponization of standing. Once again, Article 3 limits the power of federal courts to actual cases and controversies. Pro se litigants, especially those that's trying to get out of a debt or stop a foreclosure, especially them. Read that backwards. They bring up Article 3 in state court to argue that the lender or debt collector lacks standing to sue them because the bank cannot prove a tangible injury. Under the fall, right there. The bank can't prove a tangible injury. That is the hallmark of social media gurus or just the people. That's the hallmark of them arguing securitization. You already got paid from the investors. So since you got paid, you can't prove a tangible injury. You do realize those arguments are almost 20 years old, but I guarantee you, I can find a case law with a 2026 caption and someone saying the same thing. Last month, somebody sent me their complaint in federal courts and they're saying the same thing. You know what I don't understand? Why do you feel like you got to defend it? It's like you send it to someone for opinion. Why do you feel like you got to defend you being wrong? You're just wrong. Like 90% of this, like I'm gonna say 97% of these space, you're just wrong. You're just wrong. It is what it is. You may believe you're right, but you're really wrong. You know you're wrong. You know you're wrong. Bank created money out of the thin air. Oh, what's another one? Since the securitization took place, since they got paid by the investors, they can't prove that there is actual harm for my default. If a lawyer would raise that argument, they probably get sanctioned. Facts. Everybody look at them like, the hell is wrong with you? Not on here. Those arguments are gold. If I was to ever raise an argument like that, I would lose all credibility with the professionals. I would lose all credibility. So, the fatal flaw. Article 3 does not apply to state courts. Yeah, damn right I said it. Yeah, I said it. And you want to know why? Because you never have your cases thrown out because you cite Article 3 in the state court. No, you don't. They cited, no, you don't. Prove me wrong. Prove me wrong. Prove me wrong. No, when I mean prove me wrong, don't come to your revisionist confirmation bias document that you're studying from. Prove me wrong from a legal and court standpoint that Article 3 of the United States Constitution applies to state courts. See, this is when you got to get to the black and white evidence. And when I want you to prove me wrong with your results. Prove me wrong with your results. Don't argue nothing that you haven't been successful in. Don't defend nothing that you haven't been successful in already. See, I know y'all like to hide behind just arguing it. Prove me wrong with your own results. With your own results. With your own results that you successfully argued Article 3 in a state court and you won. See, y'all be getting away with just saying you won. Or show one little simple document. Yeah, I got to be good. Nah, what's the context behind it? They don't ever want to notice this. They don't ever want to give you context behind the shit. You want to know why they don't want to give you context behind it? Because they know the real reason about the disposition of the case. But they got to make sure the reason that they give the people is the reason that the people want to hear. They don't want to give you the straight, unadulterated, straight up, uncut reason. They got to give you the reason that you want to hear. Because you'll buy, more people will spend money on the things that they want to hear versus spending money on the things that they need to hear. Nah, this is why 98% of people don't get success. This is why people call my phone all the goddamn time complaining about a guru. Don't it, Don? No, you don't. The most glaring error in this strategy is that Article 3 strictly governs the federal judiciary, not state courts. Not state courts. Article 3 doesn't govern state courts. So why are you going in the state court talking about Article 3? Same thing for the brother, equal footing. This is why I said the brother really doesn't know what he's talking about in court. Based on his own words, what came out of his mouth in that 6-part video, he really don't understand court. You notice how he wasn't making no headway with the court. And you notice how sovereign citizens always feel like they can dismiss their own case whenever they feel like it. I'm gonna move to dismiss this. No, you can't. You don't have that power. And that's the problem with these pro se litigants and these sovereign citizens. Y'all don't have no power. You're not scaring nobody. Nobody cares. You're not scaring nobody. You're not. Nobody cares. They're not even paying you no mind. They're just giving you a due process and letting you just talk. Oh, they just talk, wasting time. State courts are created by, like I've always been saying, state constitutions. And the state constitutions got their authority under what? The amendment that none of y'all ever like to talk about. The ones that y'all skip over when y'all be cherry picking the Constitution, y'all seem to skip over this amendment. the state constitutions get their authority from the 10th Amendment. Wow. That's why y'all never want to talk about the 10th Amendment. Y'all don't ever want to talk about the 10th Amendment. Yeah. It's reserved to the states or the people. Not the people like you and I, like the people of New York. Just like you got the Commonwealth of Virginia, the state of Indiana, the people of New York, that. Y'all really thought the states were just going to just lose all their sovereignty to the government? Remember, the states came together to create the federal government. You really think that they were just going to hear federal government? Y'all just run shit. States be bucking the federal government all the time. But y'all, so the federal government, the federal law, it has so much power over you, state. Yeah, whatever. Y'all be getting your asses spanked in state court. Y'all be getting spanked in state court. I be seeing your docket sheets. Y'all be getting your ass handed to y'all in state court. So I knew you ain't nowhere near to step up to the big boy federal court. Oh no, they way more strict over there. Oh, they strict. You better know them court rules and procedures before you step in federal court.
Facts.
Who filed a lawsuit in state court, and the other side's immediate response was a notice of removal to federal court. That's never a good thing, by the way. It's never a good thing. Let me ask yourselves a question. Why wouldn't you file your case in federal court anyway, since you got a whole bunch of federal statutes and federal questions? Why? I'm just trying to get the mindset, because I'd really be baffled. Why wouldn't you file in a federal court anyway? Oh, can't make the connection? Huh? Oh, it's in state. It started in the state, so I'm gonna file it in the state. Like, even that mindset right there is like, okay, you don't understand court strategy. To y'all, I think it's just my facts. This is what happened. Do a little research, file. No strategy. And then y'all be all over the place and y'all complain. And then y'all always making a legal conclusion. And then you rarely ever cite any case law. And then you don't even support your legal cause of actions with factual evidence, black and white. It's all theories.
Yep.
And y'all be passing it off as facts. And then you be expecting the judge to go along with it. The mechanism, this automatically transfers the entire case out of the local state court and drops it onto the docket of the nearest U.S. district court. And the goal, it immediately strips the pro se litigant of any hometown advantage they hope to have with a local county judge and forces them to play by strict federal rules. And this is the part where pro se litigants are the most vulnerable. Right there. This is when y'all get drug out into deep waters and don't know what to do. And this is when you start screaming conspiracy. They just don't want you to win. You can't win in court. And this is when you see online posts, don't go to court. Don't ever go to court. You don't have rights in court. You're a ward of the state. You're not recognized in court. Don't step in people's courtrooms. Anytime you hear a content creator says that, translation, I don't know how to win in court. I don't understand court. That's not my forte. So instead of saying that, they'll tell other people, nah, y'all don't go to court either because I don't know what to do in court. So y'all shouldn't go to court either. But these are your these are the mindset of your teachers. We know. Court. Y'all be getting y'all asses spanked in federal court. I'm talking about whoosh, 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 whoosh. When you understand court, you can play around in the gray area. Let me try to slide this in there. Standing argument. Their written order usually reads like this. Stripping away the sovereign citizen or template language, judges will explicitly call out the nature of the filing in their introduction. They often use standard language to warn the plaintiff that confusing legal jargon would not save their case. Example, this is from a real case. While pro se pleadings are held to less stringent standards than formal pleadings drafted by lawyers, the court is not required to accept legal conclusions couched as factual allegations, nor is it required to accept bizarre, incomprehensible, or sovereign citizen theories of law. I literally retrieved that from multiple judges in their opinions written for sovereign citizens. Yeah. It's gotten so bad that they got standard written orders to deal with you. Oh, it's like which one? Oh, we got sovereign citizens. All right, I already got an order written up for that one. Just slap me up. Let me go ahead and just type that one up. Yep. Which one? It's like they got a file. All right, we got the National Patriots. Here's the order dismissing theirs. Which one we got? Clerk Miss Jane Smith. What was it again? In the judge's chambers. Well, we got a federal question standing in the constitutional arguments. Okay, let me pull out this order. Already got it written up for him, waiting on him. Hey, yo, they already got they already got pre-orders. I knew you could help yourself. It's that auntie shit. Yeah, they already got pre-orders. They already got orders already pre-written. What the hell? They already got the order ready. They just like, all right, which case is that? All right, throw that order on it. Yo, this shit crazy. Oh, shit. Number 2, dismantling the state court Article 3 argument. When addressing the plaintiff's attempt to use Article 3 to block a lender, the judge's opinion will systematically explain why the argument is legally invalid. A typical judicial analyst looks like this. Look, plaintiff's reliance on Article 3 of the United States Constitution is misplaced. It is a foundational principle of American jurisprudence that Article 3 applies exclusively to the federal judiciary, defining and limiting the jurisdiction of federal courts. State courts are creatures of their respective state constitutions and are not bound by Article 3's case or controversy restrictions. Because this action originates... Hold on. You mean you said state courts are created by what? State constitutions? Well, the U.S. constitutions trump that. Go bring an Article 3 in state court and see how much trumping it does. And within state jurisdiction, Article 3 standard requirements are wholly inapplicable to defendants' right to foreclose. See, they will come online and be like, you're wrong. No. Well, go make the same argument in court. That's all you do. Go do it. That's all you do. Go make the same argument in court. Just go do it. Closure. Go do that. All you gotta do is just go make the argument. I'm wrong. Cool. You should win then if I'm wrong. It should be a cakewalk for you to walk into a state case, cite federal Article 3, and get your win. It's a cakewalk. Let me just read it again for you. And this is actually what judges have said. Plaintiff's reliance on Article 3 of the United States Constitution is misplaced. It is the foundational principle of American jurisprudence that Article 3 applies exclusively to the federal judiciary. Right there. So the question remains, why are you bringing Article 3 standing into a state court? Because you thought Article 3 of the Constitution just trumps over all state constitution laws, court laws, state courts, not knowing that the states are sovereign. They're their own sovereign states. And the 10th Amendment, the U.S. Constitution, does not govern many state actions because the states have the 10th Amendment of the United States Constitution. That means anything that wasn't expressly mentioned in the Constitution is reserved to the states or the people, aka the people of New York, aka the state of Arizona, aka the Commonwealth of Virginia. Meaning, if it's not expressly written in the Constitution, the states govern, like driving. Driving. Governed by state. Where's the DMV located at? In each state, right? You got the Virginia Department of Motor Vehicles. You got the Maryland Department of Motor Vehicles. You got the District of Columbia Department of Motor Vehicles. You got the Philadelphia Department of Motor Vehicles. Do you see the U.S. Department of Motor Vehicles outside of the DMV? Just like when you see the United States Postal Service, which is governed by, created under the Constitution. You see the United States Postal Service, right? You don't see the Virginia Postal Service or the Maryland Postal Service or the New Mexico Postal Service. You see the United States Postal Service. Exclusive federal jurisdiction. But you do see each state's Department of Motor Vehicles. Why don't you see the United States Department of Motor Vehicles? Because that's when driving will be governed under federal law. Just like the United States Postal Service. You commit a crime against them, you're going to the feds. Federal government jurisdiction. But you don't see that with the driving. Want to know why? Because driving is state laws in which the states have the rights to create their own laws based on their own state constitutions and further grant by the 10th Amendment. And this is one argument that they will never refute. They can never defeat that argument. In limiting the jurisdiction of federal courts, state courts are creatures of their respective state constitutions and are not bound by Article 3's case of controversy restrictions. Because this action originates under state law and within state jurisdiction, Article 3's standard requirements are wholly inapplicable to defendants' rights to foreclose. You know what? Disregard it. Go file it. Just go ahead. Good. Dismissal with prejudice. Number 3, if the judge determines that the pro se litigant is simply using internet templates to stall or that no amount of rewriting the complaint will fix the lack of a real legal claim, they will issue the final blow. This is the final blow. Bam! When you go so far down the sovereign citizen rabbit hole in court, this is the final blow. This the how you can. Because plaintiff's federal claims are legally frivolous and cannot be cured by amendment. Plaintiff's complaint is hereby dismissed with prejudice. The clerk is directed to close this case. Yep, that's coming down the pipeline for you. Oh, yeah. It's coming down the pipeline. Oh, yeah. Oh, yeah. Oh, yeah. This is why they really don't ever want you to see their case or get the backdrop of their case. Do you know how many times people like Darren and other people have these gurus actually looked up their case? I got a group member. He lives in Pacer. He be pulling all these people's cases. Do you know they be losing their cases? They'll come online and talk about they won. They be losing them. Lost. Sovereign citizen claims in court. Yeah. That's what I didn't want. Now, Federal courts frequently dismiss pro se foreclosure delay lawsuits that erroneously apply Article 3 standing arguments to state-level contractual disputes, often finding such complaints rely on meritless boilerplate templates. When cases remain in state court, lenders utilize defenses like the tender rule, requiring borrowers to possess the full loan balance to challenge a foreclosure, or in cases of repeated violence by seeking a vexatious litigant declaration. So, the pleading standard mistake, Federal Rules of Civil Procedure Rule 8 versus the reality. You want to have that? You can have it. The concept under Federal Rules of Civil Procedure Rule 8, subsection A2, probably something that a lot of pro se litigants, you don't even know that rule exists. Don't even dare to even think of the rule. A complaint must contain a short and plain statement of the claim showing that the pleader is entitled to relief. Rule 8. And 9 times out of 10, y'all don't even satisfy that. Show that when you have all these sovereign citizen online social media arguments. Remember, y'all, those arguments are only popular here. In the real world, in real court, they are rejected at the rim. Dikembe Mutombo. It's only good for arguments and debates on here. But when we get to the real world, none of that shit works. Highlight. Apply for a mortgage modification under the Home Affordable Modification Program. We're gonna mortgage servicer. I'm gonna skip through and I'm gonna get to the last one. But this whole video will be edited and uploaded so you can catch the context of the good moments and the shit that was woo-wee. Entirety. July 23rd, 2012. The court found that absent a trial period plan agreement, which creates privity of contract, a suit that seeks a general enforcement of the HEMP guidelines, all of the documentation required under the HEMP guidelines. Now we're going to get here. I yield to the courts. I don't try to make the courts yield to me or rewrite the rules. I yield to the courts. Like I yield to the courts. This is why me and the courts, we on the same page. For the most part, we on the same page. Facts. With the New Culture Empire, the courts are always going to make them respond to my complaints. That's a fact. They're never going to sua sponte dismiss my complaint, file off the break on their own accord. Never. Never. Don't never say never. 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 Ever. It's my complaint. They're always going to order them to respond. Facts. They're always going to order them to, oh, you need to respond to this right here. Facts. And I'm speaking on something I already... Yo, can you imagine? I'm speaking on something I've already proven. Not a theory. I've already done it. A lot of things I be telling you about, I've already been there and done that. Respond to my 30-page motion for temporary restraining order and my 90-page complaint inside of 7 days. Wow. What? Pressure. Yo. Shit. Can you imagine being asked to respond to my TRO and my original complaint within a week? Woo! You know how much research you got to do to respond to me? God almighty. Yeah. It is well established that the relationship of a bank to its customer in a loan transaction is ordinarily a contractual relationship between debtor and creditor and is not fiduciary in nature. So all your breach of fiduciary claims against the bank, there you have it. The relationship is a debtor creditor. You're the debtor, they're the creditor. This breach of fiduciary duty, nope, never flies, never will. Have been exceedingly reluctant to find special circumstances sufficient to transform an ordinary contractual relationship between a bank and its customer into a fiduciary relationship, or to impose any duties on the bank not found in the loan agreement. Remember what I always say, the normal everyday meanings always mean something esoteric in this space. What did I say? A normal, everyday, simple, everyday transaction. And notice how, remember, they said I was crazy because I'm not looking at it from an esoteric, because I'm not splitting hairs on every word. When I'm going by the normal, everyday, practical life, what is the court doing here? They're taking the normal, everyday, simple mortgage transaction. Every day what you see on this face, they're not getting too in deep, exactly what it is. They're not doing all this esoteric stuff. The object is to catch bees with honey, not with vinegar. You catch the bees with honey. Facts. Following the normal, everyday, practical, everyday court rules and procedures is going to get you farther than all that extra stuff. The everyday, the same laws about, you don't win, you can't win. You mean to tell me you can't win citing everyday law? Following everyday court rules and procedure, you can't win? Nope, that's not how they say it. It's absolute. No. That is how you win in court. In cases where there are none of these special circumstances and no contractual basis for a specific duty of care is alleged, the lender owes no duty of care to its borrower. Notwithstanding this case law, appellants argue that Wells Fargo owed them a duty to process their loan modification application underhand, and that Wells Fargo breached its duty when it deviated from the applicable standard of care in failing to process their application. This contention does not withstand scrutiny under Maryland law, aka when you take their claim that they owe the duty, the standard of care, and failing to process their application, what did the court just say? I'm going to translate it and set you. When you take that claim and put it under the legal lens, it falls apart every time. Remember, 5 lenses of the contract. Every time. Patent pending, trademark pending with the United States Patent Office. Yes, yep. I am patenting the term. It's already pending. Already got the application number. The 5 lenses of the contract. Woo! Created by me. Woo! No one. Ever. Woo! I'm a creator. I'm a creator. I'm a creator. I create. I create. We all create in our own right. I create, they duplicate. As explained above, contractual privity has not been remotely pled here. Appellants argue, however, that the facts that establish contractual privity in Jackass also exist here. Now, okay, so let's get to, because they're getting into the Jackass. He's a sovereign citizen. Here we go. He's a sovereign citizen. Here's the case. Here's the case. 250,000 to my account. I could live off that for a while. Hold on. Accent real estate he owns. Here we go. Pages, and we're gonna wrap it up for the night. Here we go. This is 2017. This is John Jones Bay. As I don't mean to be biased, but as soon as I see the word Bay or L, sovereign citizen. As soon as I see a Fez, sovereign citizen. Sorry. Or more-ish American. You know that's not a term. You know, like I told you, I as a guy I talked to still to this day, we went to high school together. Actually I met him in 8th grade, and we talk on Facebook. And his parents are from Morocco. So all throughout I've known him, every summer he would go back and come spend half the summer in Morocco. So as I got older, I started asking him about this. He had no clue of what. He's like, what? He's, bro, we don't call ourselves Moors. What are you talking about? Moorish American? He said, Morocco is the United States. He's like, man, he said, bro, you okay? I said, no, it's not me. It's not me. This is what people be saying. He said, families from Morocco. Bam. I think they would know the custom over there in Morocco, wouldn't they? All these revisionist history books that people try to use to find an identity. Stop trying to look for your identity through a damn book all the time. And if you're going to look for your identity, know your roots, do it because that's just what you want to do. Don't do it because you're trying to get out of a debt. Don't do it because you're trying to justify not having a driver's license, because you're being disingenuous. But it's impossible to not be disingenuous in this space, because that's all it is, disingenuous. You're going to admit facts. You're not going to be honest. You're going to lie. You're going to stretch the truth. Oh, it's all that. Tanya Walton Platt is the judge. This is John Jones Bay versus State of Indiana. Can you turn it around a little bit? Before, pause it. John Jones Bay, who describes himself as an Aboriginal, indigenous Moorish American, filed in the district court where he labeled a writ of mandamus seeking to enjoin the state and county officials from taxing real estate he owns in Marion County, Indiana. He also asked that the defendant officials be ordered to refund the taxes that he paid and to compensate him for their alleged wrongs. He asked the district court to award him. Now let me ask yourself a question. How much money do you actually think he asked the district court to award him? You think it was something modest? It's never. It's always going to be some astronomical number that they're never going to get. But I actually like this breakdown. Just award him the money he paid out of pocket. No, it's never that. It's always some 15, 30, 40, 50 billion dollars. Remember, chasing the money through lawsuit. So when they find the damages and where the statute says, hey, you may be entitled to monetary damages, when they calculate the numbers for their damages, they're not actually calculating the numbers to actually coincide with the actual harm. No. This is how they're calculating the numbers. Shit, I don't never got to work again ever. 100 million there. Shoot, I could leave some shit for my kids. And I could start me some businesses. I could put about 250,000 to my account, and I could live off that for a while I start my businesses. Let me add 250,000. Damn. I do want a house over there in the hills somewhere. Let me go ahead and put extra $3 million there. That's how they come up with their damages. That's the mindset.
Oh, shit.
That's the mindset.
Hey, yo.
He asked the district court to award him $11.5 billion.
But there you have it.
There you have it. The court refused and granted the defendant's motion to dismiss, precipitating this appeal. See, when they file appeals, they're not filing appeals because they got merit and they think the judge incorrectly applied the law. No, they're filing appeals to protect their belief system. They're filing the appeal basically saying, I can't be wrong in my beliefs. I can't be wrong on this $500 packet I paid for. I can't be wrong. I've been thinking like this for a long. I can't be wrong. This is now my identity. I see the world through this lens. It can't be wrong. No, I got to appeal. Not because I have merits, because I can't just not. I got to appeal. I can't be wrong. This is why they appeal. Bay says he's a sovereign citizen. Oh, make sure.
Right there.
Second paragraph. Bay says he is a sovereign citizen and therefore can't lawfully be taxed by Indiana or subdivisions in the absence of a contract between them and him. So for the ones who disavow the name sovereign citizens, what do you always say? The ones who say, I ain't a sovereign citizen, what's the same talking point? Oh, I don't consent to that. There's no contract between us. There's no contract between us. There's no contract. I don't consent. What's the difference between the ones who says they're a sovereign citizen like him and the ones who deny the name? What's the difference? In the ideologies, the talking points, what's the difference? CL versus AmeriCredit Financial Services, Inc. for a description of the beliefs of so-called sovereign citizens of alleged Moorish origins. We have repeatedly rejected such claims. United States versus Jonathan, 2014. United States versus Beneby, 2011, 7th Circuit. United States versus Hilgeford, 7th Circuit, 1993. United States versus Schneider, 7th Circuit's 1990.
Damn.
Went back to 1990 making these arguments. So when I say the same things I hear online today are the same arguments that they raised in court for the past 40 years. And one of these cases dates back to 1990, and they're still saying the same things online today in this year 2026. We do so in this case as well, aka reject, and thus affirm the district court. But we want to take this opportunity to examine the rights asserted in this, as in the other cases we cited, by persons describing themselves as sovereign citizens by virtue of their alleged Moorish origin. I can hear him now. Of course they're gonna say that. Of course they're gonna say that. They don't want the truth out. They don't want you really knowing your rights. They don't want you understanding that you own everything on the land and everything on the land is yours and you don't have to work for nothing. You could just squat in a house as soon as you see something. You don't have to put in work like everybody else. Everything is just yours and you just got to claim it. And you got to claim the estate and you got to claim your status. You got to show up the back door with the new name of Al-Shamik, Al-Shabazz, El-Hakim, and they're going to give you everything. Cancel your contracts. Turn your birth certificate back in. Totally just deny you're a United States citizen. What about your birth certificate? Oh, that was before I became enlightened. Now that I'm enlightened, I want to start my life from today on. Well, what about the other stuff that you had to driver's license? But you was paying your taxes 5 years ago. No. But you got an auto contract and you was paying back on your auto loan. I don't want to talk about that. Don't want to talk about that. Brother, you got your passport. I don't want to talk about that. I swear I'm not making this part up. This is really the court case. By persons describing themselves as sovereign citizens by virtue of their alleged Moorish origin, most of them are African Americans who belong to the Moorish Science Temple of America
and claim to be descendants of the Moors of Northern Africa, though they are not.
Tell mommy that she was going grocery shopping.
Oh shit.
You in the background being bad. Being bad.
Moors are of mixed Berber and Arab descent, rather than being African American in the usual sense of being descendants from Black Africans. Don't tell me the judge is giving you more of a history lesson than these Moors gurus. The judge? Y'all let the judge scalp y'all? Where my Moors at? Where my true norths and true light and true star, true crescent? You let the judge scalp you on the history? Damn. Where my Usar motherfuckers at? Usar, fight back. Y'all still got license plates for $50? You still got tags for $50? You still got your ID cards for $50? The original purpose of the Moorish Science Temple of America, founded in the 1920s by Noble Drew Ali, whose followers called themselves Moors, in place of more conventional designations such as Black, African American, and color, was to claim government recognition and respect as full citizens rather than the second-class descendants of slaves. Leah Nelson, Sovereigns in Black, Intelligence Reports by the Southern Poverty Law Center, August 24th, 2011. The Moorish Science Temple of America focuses on uplifting its followers and encourages them to vote in U.S. elections so that they can escape political slavery. Spencer Drew, Moors Know the Law and Religion. So you fake Moors who's using the banner, which has nothing to do with you trying to say you're more to get out of the day. You want to know why? Because I'm friends with a good brother that is a high-ranking member of the Moorish Science Temple of America. You know what he told me? He said, we pay our bills.
Facts.
No, that's part of being a man, being a Moor. Handling your responsibility as a man under the Moorish Science Temple is paying your bills. Making sure your family keeps a roof over your family's head. Paying your bills. So when we get to this Moorish Americans not paying the bills, you ain't got to pay your bills on the land of the state that you reside in. Where'd that come from? The Moorish Science Temples of America's home office, located in Washington, D.C., has issued a statement clarifying that the organization is neither a sovereign citizen movement nor a tax protester movement, and that it was not founded for its members to become anarchists or conspiracy theorists. Moorish Science Temple of America statement on radical and subversive fringe groups, July 15, 2011. But the Moors don't want to talk about that in these spaces. They overlook stuff like that. A Moorish Science Temple of America temple in Georgia denounces sovereign citizen propaganda as completely asinine and asks that Moors not adopt the ideas of these European groups who at their core hate Moors' very existence. So, but like I said, 99.99% of you fake Moors online, you Moors get out of debt. You are adopting white supremacist ideologies like Roger Elvick, Risson Strout, who has deep connect ties to Timothy McVeigh and Terry Nichols. government anarchists, and you African Americans, you are adopting white supremacist patriot ideologies. The same people who will burn your ass at the stake if they had their way. But you're sitting here quoting their ideologies. You ought to be ashamed of yourself. For what? Free money. Fucking cowards. For money. For things that your lazy ass won't get up out here and go get on your own. Yeah, you fucking emperor, empress, lion emojis, and all those fucking avatars, king of the descent. Give me a fresh shit out of here. Don't respect it, nor do I respect you. Completely asinine and acts that Moors not adopt the ideas of these European groups, the patriot community, who at their core hate Moors' very existence. Frequently asked questions. Moors Science Temple of America, Georgia. moorsciencetemple.org/FAQs. But clearly, sovereign citizen ideals appeal to many self-described Moors who combines those ideas with Ali's teachings in an effort to reclaim and rewrite Black history. This is in a judge's order. This is in a judge's order. This is in a judge's order. A judge's order. This is a judge's order. A cold-blooded history lesson that I love. A cold-blooded history lesson. I love it. Because they, oh, no, we're not. We ain't using white supremacist stuff. We ain't adopting that. Well, anytime you talk about in the state a secret account, that's exactly what you're doing. Because Roger Elvig, a person who had deep ties to the white supremacists, he created the secret account, the exemption account. I don't care that you call it in the state. I don't care that you talking about reclaiming it with a 1099, a 1040, 1041. That is that white supremacist ideologies that you are adopting. Black man, Moor man, brown man, whatever man. Adopting their ideologies, and they would let you nowhere near in their groups. You want to know why the patriot community always went at the Moors? It wasn't because y'all was doing things incorrectly. They hated that y'all was adopting their ideologies. That's what they hated. Y'all was biting off their ideologies, and they hated it. Pathetic. Yeah, pathetic. You're pathetic. No respect. I don't respect none of y'all. No respect. Pathetic. You're pathetic. You're an embarrassment. To my you're an embarrassment. You're an embarrassment. I'll be embarrassed. Pathetic. You're so desperate that you got to follow a white supremacist ideology to get some free money. You're pathetic. For example, the Moorish Order of the Round Table uses 18th century treaties with Morocco to distinguish free Moors from Africans who could be enslaved, and teaches that courts have no jurisdiction over Moors. Nelson, Sovereigns in Black. Other groups claim that their Moorish nationality gives them the status in the United States of an indigenous people, although the logic behind this claim is deeply obscure. Renita Bey teaches that Europeans are latecomers and Moors never granted them citizenship. Ouachita Nation comes under investigation. Intelligence report, Southern Poverty Law Center, June 15, 1999. The Southern Poverty Law Center has put out some of the most in-depth, detailed, reports on the Moorish American sovereign citizens and patriot communities, and it will help you understand their ideologies even more. And the Anti-Defamation League has done so as well. Classic reports out on these people. Classic. When I say they did their research to the early origins. They do their research to the beginnings, where it started from. Wasn't a black man around when it started.
Facts.
Wasn't a black man around when this movement started. The black man bit from the patriot community. That's all you did. You bit from them. If you don't know where you came from, you won't know where you're going. She teaches her followers that they are Moors from Mu, who traveled to North America before Africans did, when the world had only one continent. Many sovereign citizen organizations teach that whenever a Moor's name is spelled in capital letters in a government document, the name identifies not the individual, but instead his corporate shell identity, or in other words, a straw man controlled by the government. That came from the patriot community because they were the first ones to assert that. Absolute facts. What the hell was I thinking? They were the first ones to assert that. Think it, we got 50% of the goals completed. Could we get one? Could we get one more? Could we get one more? Although the Moorish Science Temple does not buy the sovereign citizen line, many of its members do. Many of them argue without any basis in fact that as a result of the 18th century treaties, the United States has no jurisdiction over its Moorish inhabitants, who are therefore under no obligation to pay taxes.
Hold on.
You are a United States citizen.
Hold on. Why? Hold on. Why the hell is it not showing? The problem I'm trying to get to understand is that's not what I'm looking for. Hold on. Let me do this right quick. Screen sharing. Why was it stuck on me the whole time? Let me do this. Let me do this for a second. Let me do this. Google Chrome. I'm trying to figure out why the hell this shit wasn't. Yeah, this shit crazy as hell. Because it's supposed to be sharing my... Oh, let me see something right quick. It's supposed to be sharing this. The screen. There we go. It's supposed to be sharing that. But it's not sharing that. Oh, let me see something right quick. It's supposed to be sharing the actual
amendment, in which the 14th Amendment was created in response to the Dred Scott case ruling by the Supreme Court, which declared African American descendants, slaves in this country, property, not human beings, meaning they did not have the protection of United States citizens under the Constitution. The Congress at the time, around the First World War, Abraham Lincoln, they wanted to change that. So the Supreme Court ruling in Dred Scott would have kept Africans being viewed as property, 3/5 of a man. So the Congress did not like the Supreme Court ruling, so they created the 14th Amendment.
that is so much absolute facts. Like, I can't even, there is no connection to the original intent to the 1933 version of the 14th Amendment. And you know what's so crazy about that? That was a patriot white supremacist thing where they wanted to take the original intent off of it being about African Americans at that time and make it about, oh, they're trying to enslave us under this. That's BS. Do you know how many years we had to fight to get that? 1619, when the first slaves landed in Virginia. 1863 is when they first was able to be recognized as human beings. And they took the historic history, erased it, and said, no, it's about this 1933. That's crazy. And I don't understand why any people wouldn't. That's great. Why would you? They just eliminate. And then we had African Americans adopting that. They didn't even know the real intent about the 14th Amendment, because if they did, they'd be like, hell no. Hell no. The 14th Amendment was not about making everybody slaves under the government, corporates, and the private bankers. And they put that in those documents. They put it in that literature. It was a lie. Because if you look at the Dred Scott case, and then you look at Congress's response to the Supreme Court, look at the year, go research the year when the 14th Amendment was passed and see if it was 1933 or see if it's back during the times of slavery in the 1863. That's all you need to know. So and as African Americans, you ought to be ashamed of yourself if you adopted that 1933 14th Amendment citizen. You ought to be every time they turn around, they're trying to erase history. You ought to be ashamed of yourself. Because if it wasn't for Congress doing that, I mean, who knows later on, but around that time, we still would have been viewed as property and not afforded the protections as human beings under the Constitution, because we was viewed as property, not human beings. They didn't go to jail for hanging us. They just said, hey, they're hanging their property. But once the 14th Amendment was passed, I'm not saying it still didn't happen, but they had to be more discreet about it. To today's times where we are afforded full protections under the Constitution. But to take that and say, no, the 14th Amendment was around 1933 to make us slaves, it is a slap in the face to the people who came before us, who sacrificed their lives for the freedoms that we enjoy today. It is a slap in the face. And before I even got into this stuff, I already knew the historic meanings about the 14th Amendment because I had to do a book report at high school on it. I had to do a presentation. That was my assignment. Yeah. What does that have to do with 1933? You're trying to trick the American citizen and being shadow paper for the government.
Was the 14th Amendment created in 1933? Around the stock market crash? Around the Mercy Banking Act? What year was the 14th Amendment enacted and passed? Hundreds of years before that. So how do you take that and tie it? How do you take its original intent, its original year, and tie it to 1933? You see, when you break apart the claims, they don't even know why they believe what they believe. That's why the 14th Amendment was passed. Because every time the Supreme Court makes a ruling that Congress doesn't like, history repeats itself. If you don't know where you came from, you don't know where you are, how you got here today, or where you're going. Because history always repeats itself.
Facts.
Every time the Supreme Court makes a ruling that Congress doesn't like, they bypass the Supreme Court ruling by amending the Constitution. We got another one.
That is 100% true. Every time Congress does not like a Supreme Court ruling, they amended the Constitution. Now I'm about to talk about the income taxes, because the income taxes was invalidated under the Pollock holding. In the Supreme Court case, in the Pollock case, income taxes were declared unconstitutional in the United States on multiple occasions. On multiple occasions. If you go back and trace the original sources of the income taxes back to the wartime profits, the reason why the income taxes was first initiated in the United States was to assist in the war, World War I, wartime measures. And I'm not just World War I, the wars 1861, it was a wartime measure thing. And then it did away with for a while. Then they came back from you. That's why I have a webinar class over the historic tax laws. I highly suggest you pay the $250 and enjoy the whole historic tax law series, because I broke it all down. I went back into my historic research files and presented the historic income taxes. Why do you think I filed 0 returns and I have in 6 figures a year, over 6 figures a year income, but when I file my returns, it's 0? Because when you go back and do your historic research, you can see all the cuts, the crevice, the woovers, the in-betweens. If you don't go back to the origins, you never know how you got here today. The truth is always in the origins. Oh, yeah. The Pollock case, where the Supreme Court in Pollock invalidated income taxes as unconstitutional. Congress didn't like it, so what did they do? Welcome to the 16th Amendment. That's okay. Although the Moorish Science Temple does not buy the sovereign citizen line, many of its members do. Many of them argue without any basis of fact that as a result of the 18th century treaties, the United States has no jurisdiction over its Moorish inhabitants, who are therefore under no obligation to pay taxes. That is base position. But okay, so what they did was TikTok restricted the showing of this video. This is why on TikTok, you just see my screen from StreamYard. But on StreamYard and YouTube, you can actually see the video. TikTok actually restricted this video. They didn't like the message. They didn't like what I was saying. No, that's why you can't see it. Because you was able to see it, but that's why it's stuck on mine. Because I got it shared all over. And if I'm sharing it to my StreamYard is sharing if you go on YouTube, you can see the video. But they blocked it off right there. Oh my gosh. I love you, TikTok.
Him to an 11.5 billion refund from the state of Indiana or its subdivisions. nor is there any basis for his contention that he is not required to pay any taxes because being a Moor makes him a sovereign citizen. He may be a Moor, but we emphasize in the hope of staving off future such frivolous litigation. He is not a sovereign citizen. He is a U.S. citizen, and therefore, unlike foreign diplomats, has no immunity from U.S. law. It's not what you call yourself. It's how you are treated.
Now, let's get the triumph. Facts.
If you don't like when I say it,
I'm gonna let the judge tell you.
I'm gonna let the judge tell you then.
We're gonna be saying the same thing.
Because the judge ain't doing nothing but saying what I've been saying. When I've been encountered these Moors, I was saying the same shit to them. Shout out to my gifters. True light in the building. True seeker. Shout out. If you don't want to hear me say it, if you don't like it coming from my mouth, say that was talking about with these Moors, and let the judge tell you.
That's
They're going
it.
to tell you the same thing.
That's it.
Nor is there any basis for its contention that he is not required to pay any taxes because being a Moor makes him a sovereign citizen.
And when the courts say any taxes, it's italicized. See, there's a tricky thing about taxes. You got to understand that there's two definitions of income taxes. It's two definitions. You got the historic definition of income taxes, then you got the definition of income taxes under the Internal Revenue Code of 1986. The default position is that the IRS is going to go by the 1986 version of the income taxes. But just because the 1986 Internal Revenue Code, the latest one they go by is 1986. And should I even say it? Sorry, y'all. Sometimes these gurus do mess it up. Send me a DM and get into my historic tax class that was held last year. And you'll get all the answers and everything you need to know about income taxes and whether your income is taxable or whether it's not. Based on what they say. I can't do it because all they're going to do is bite. I'm sorry, y'all. They bite me too much on here.
He may be a Moor, but we emphasize in the hope of staving off future such frivolous litigation. He is not a sovereign citizen. He is a United States citizen. And therefore, unlike foreign diplomats, has no immunity from U.S. law. All of you are United States citizens because the 14th Amendment was created so we can have the protections under the Constitution as citizens.
Yo, and that's not no lie. You are a United States citizen, whether you want to believe it or not. You are going to be treated as a United States citizen because the 14th Amendment was non-negotiable. Remember, any person born or naturalized in the United States is a United States citizen, and a citizen of the state or where they reside for the sole purpose of giving you protections under the Constitution. You can't get around it. You could say, I renounce it. I'm a you are a United States citizen. And if you check off, like, I'm a non-United States citizen, they're going to look at your file. You got a social security number, you got a birth certificate. Where was you born at? What hospital was you born at? Want to know why the birth certificate is important? Because it shows that you were born within the United States. That's why. You was born within the United States. So they're going to go by your birth certificate, Department of Vital Statistics. They're going to go by your birth certificate, and they're going to go by your social security number. As soon as you was issued those, you are a United States citizen, regardless of how many processes, how many packets, how many documents you send in, how many status corrections. If you wasn't born in this country of Morocco and obtained dual citizenship over here, that Morocco declaration means two diddly jack shits to the government. Property. This is why the 14th Amendment was passed. This is why it was passed in 1863, around that time, instead of 1933. This is why you are a U.S. citizen. So you can have the protections. They passed that for African Americans. That's why they passed the 14th Amendment. That is exactly why it was passed for us. The 14th Amendment was passed for African Americans. That was the original intent. But it applied to anybody that was going to be born. But if you look at the time in this country, it was really that so African Americans wouldn't be looked at as property and looked at as human beings in the U.S. That was the intent of Congress doing it at that time. But even though the original intent was African Americans, it applied to anyone who was born over here moving forward. But the original intent was to overturn the Dred Scott case. Remember, Congress has historically used amendments to the constitutions to overturn Supreme Court rulings that they do not like. That's all it is. That is historic. See, we ain't talking set you and five lenses. We talking historic. Y'all just hear me talk about mortgages, autos. I cover multitudes of topics. I cover multitudes. Facts. Even down to that esoteric stuff that they be talking. Greek mythology. Yes. And I put that on my mother's dead cat, Dusty. She loved that cat. That was the sole intent, because the Dred Scott Supreme Court ruling would have left this as property. Facts. That's why we're U.S. citizens. Facts. So take 1863. How does it apply to the 14th Amendment being somewhere tied to 1933, pledging us as collateral for the U.S. government debt obligation? How does that connect? That was the original intent for the 14th Amendment was to give us our protections. That was the patriot community thing. That was never anything that was never any ideology but theirs. And the patriot community has historically had racist white supremacists within their ranks. See, you wouldn't know this unless you did your historic research, as I'm talking about. Under the Constitution. See? Indeed, his suit is frivolous and was therefore properly dismissed. He was lucky to be spared sanctions for filing such a suit. And if John Jones Bay didn't do anything, I really hope that he actually looked at this opinion and really reevaluated his mindset, because this was one of the best opinions that I've ever read on this topic. This would make anyone really sit back and be like, yes, hold on. Yes. And he had, and it's crazy because he cited sources that I've researched. He cited well-qualified sources. When the court cites sources, they're well-qualified. They don't cite just anything. They're well-qualified. The sources he cited is the John Bay case. What I'm talking about. The sources, if you go research the sources the court cited around this Morrison, it will blow your mind away. Because 2 of them I've already read. Yo, they did extensive work. Brilliant work. I'm telling you.
Every time I hear these Moore Bay Ales talk, I don't believe none of them wins. They don't ever win in court. None of them wins in court. They don't ever win.
None of them.
With these arguments.
None of them.
Although we have discussed the Moorish Science Temple of America at some length, our aim was to introduce readers who may not be familiar with the sovereign citizen movement to its principal institutional establishment, meaning the same thing I always say, even to my group. Even when we have a webinar, it may be boring in the beginning. It may feel like you wasted your money. But before we get current, we must go back over the origins,
Facts.
the history of it, so you can understand how we got here today.
That's a fact. That is a 100% fact.
That's why we went over the origins of mortgages when it was first instituted in American society. So you can see how we got from there to here today. And when you see where it's at today and knowing where you came from, you always find the similarities.
Facts.
They do the same thing. How it morphed into this today.
They do the same thing.
I realize, I see how the banks used to hold the mortgages to maturity or pay off, to maturity or to pay off. Now, with the evolution, we see why there's no need for them to do today. Oh, I get it. I understand why the banks are reluctant to go to the Federal Reserve to make applications to the Federal Reserve to fund our loans. It's a bad look on the secondary market if they do. So we know if they're going to the Federal Reserve, it's of a last resort. They have no one else to go to. Facts. Now I understand why when people say that the first thing the bank does is go to the Federal Reserve. See, now you will understand why those people don't know what they're talking about. This is when you're like, I get it. And then you can actually see why we go back over our origins.
Any professional is going to agree with me. There is not a professional in the secondary market that's going to disagree with me. They all agree with my teachings. T attorney told our group member and one of my friends, T Dot, you know what he told him? Because T Dot told me. He said, man, SEC said, man, that guy, whoever you're with, talking about me, you're good over there. We don't even need to talk about this every day. You're good with him. He understands. He said, I'm gonna be telling you the same shit. Oh yeah. Oh yeah.
I'll end up like them. Lost, just starting current with no understanding of what came before. Yep. We do not mean to what the? Somebody order Domino's? The hell?
No, actually, who is it?
Domino's. We do not mean to task the district judges of this circuit with having to delve into the history of every particular organization involved in every case before them. Often, the organization either played no significant role in the events leading up to the case, or if it did, nevertheless, it was an organization already well known to the court. The unusual feature of this case is that the sovereign citizen movement and its institutions, such as the Moorish Scientific of America, are at once sources of difficult litigation and not well known outside the sovereign citizen movement. The judgment of this district court is affirmed. That appellate court gave that opinion, not for Joan Bay, for everybody that's going to come behind him. As I always said, when they give their opinions, they're really giving everybody else a warning.
Facts.
Stop.
Facts.
Don't file this.
Facts.
You're not going to win.
Facts. That's all it is.
And they hate when I'm right. The sources I'm cited is 100, something that you can trust, and they have no comeback for me.
They never do.
Every time I back my assertions up with the courts. I back my assertions up with the regulatory agencies. I back my assertions up with the FBI, with the OCC, with the IRS, with the Bureau of Fiscal Service, with the SEC, case law, all the top executive branch government agencies, and the people who's responsible.
And historic law. And historic law. Let me go ahead. And historic law. I back it up with historic law. You want to go current? I can take you current. You want to go regulatory agencies? I can take you regulatory agencies. Want to go court? I could take you court. Want to go FBI? I can take you FBI. OCC, SEC, FFIC, and I can take it back to your origins. The people that believe in things in these spaces today, I know more about the history and what they believe in online than they do. They don't even know the origins. This is why they can't refute me. They don't even know the origins of the things they believe in. They don't even understand who started these things. They didn't even understand Roger Elbin, a known person that ties to white supremacy, started the whole secret account. Present day, this is where you got sending instruments with your account numbers for Social Security and the Federal Reserve routing number. It all morphed from him, the origins. That's why today it's in a state. That's why today you send stuff to the Treasury thinking there's some funds at the Treasury for you. He created that. That was never anything the government said or contemplated. He created that. That was his belief. That was his ideology. Nothing on the books of the Treasury. I've searched back, dating back before 1933, early 1900s, mid 1800s. No reason to go back to the 1700s. There's no reason. Mid 1800s, all of the 1900s, no mention of it. 1933 on up as well, no mention of it, account in our names. And then I look at all the other government accounts that are on the books at the Treasury. All the accounts are public because there has to be an appropriation to fund them, or there has to be an act of Congress. So in order for the government to have any money that's sitting off in your account at the Treasury, it must be by act of Congress or by appropriations. Because no other money in any other time in history has ever left the Treasury. And I like to give this example. Your stimulus checks during the COVID-19, they had to pass a bill. They had to make a law to give everybody $600, then $1,200, then $1,400. They had to even pass that law, had to write up a bill. And inside the bill, Americans making under 100,000 gets those rounds of stimulus. They didn't just unilaterally tap into your account and give it to you. Prime example, when you get tax credits, like child tax credits, Congress passes a law to give people tax credits. So when they pass the law, they print up the money, and then the money gets routed to the IRS to pay out the child tax credits. So anytime you get credits, refundable credits, it's already been appropriated by Congress. They make the rules, they make the law, they print the money, and then they route it down to the IRS. Want to know why? Because I know the accounts that they get parked into it's time to give someone a child tax credit. I know the accounts that they use. See, there's an IRS account, and then there's a set of accounting inside of it. That's the accounting you won't even hear talk about today online. You won't hear about it. You want to know why you won't hear about it? Because most people, the gurus, are lazy. They don't want to spend weeks and months at a time trying to understand it. This is why all their stuff that they teach is surface level stuff, easy to do, easy to follow. They are more mentally lazy than the people who's relying on them to show them the way. The gurus are mentally lazy. This is why you can have 8 different gurus selling the same thing, just a different variation of it. This is why it's easy to create an instrument to pay a tax debt, then understanding the tax laws or regulations and the statutes that protects you to ensure that the IRS follow their own rules before they assess this taxes against you. Make no tax against you. No, the easy thing to do is just send them an instrument to get